saw the most amazing story in the Toronto Star the other day. It was confusing for me, and it was confusing for the Star. They didn't know quite what to make of it, who was the good guy and who was the bad guy, because there was guns involved, and they know one thing, they don't like that. Here, let me read a little bit to you from this story. It's just so astonishing. Jury, so there's a jury involved, acquits teen who claimed self-defense in a fatal Toronto school shooting, saying he carried the gun because his neighborhood was like Iraq. Oh my God, there's so much to digest just in that one headline. I'm gonna read just a sentence or two before I bring in a legal expert to help me chew through this. A Toronto jury on Friday, so this was last week, acquitted a 20-year-old man of second-degree murder, accepting his claim that he fired 4 shots in self-defense, believing the victim, 18-year-old Jefferson Guerrier, was lunging at him with a knife outside a high school in the city's East End, or as I would say, just another usual day in the failed state of Toronto. The fatal shooting, just as classes were ending for the day on Halloween in 2022, drew widespread attention due to the proximity to students, one of whom filmed the incident on their cell phone. So yeah, like I say, just another normal one. I'll just skip ahead. The man was 17 at the time. His identity is covered by a standard publication ban. But what's so incredible to me is that he was packing an illegal gun, and he used it to shoot a guy he was afraid of, and he was acquitted. Joining us now to talk about this is Ian Runkle, a criminal lawyer who has a popular YouTube channel called Runkle of the Bailey. Ian, great to see you. There's so many more nuggets in that story that I'm tempted to read out, but I'd rather have you describe it. This kid, he was 17 at the time, obviously he was a man, was a migrant from Iraq. And he said that growing up in Greater Toronto was as dangerous as Iraq. And I guess in his defense, he says he had been shot at before. And it sounds like this school was almost a war zone where, I don't know where my sympathies should lie. And I don't think the Toronto Star knows either, because on the one hand, they hate guns, but they love migrants. They hate self-defense, but they like this guy. My head's spinning. Help me out.
One thing to remember is that self-defense cases don't necessarily have a good guy or a bad guy. A lot of self-defense cases throughout the Canadian case law are bad guy versus bad guy. So you can't necessarily assume that. And people have sort of, they say, look, this guy's got an illegal gun, so what does this mean? Well, it doesn't mean as much as people think. From what I understand, he's still facing the gun charge, that's going to be resolved later. And there's, just because they've said it's not murder, doesn't mean that they're saying that it's okay for him to have had the firearm in the first place. So he's still facing those charges. I understand that he's in custody. We might see like a plea. If he's been in custody a while, he might have a bunch of time served lined up. But Canadian law doesn't require that you be legally carrying a weapon in order to defend yourself with it. They don't say, listen, you're not legally carrying this gun, so your responsibility is to die if somebody attacks you with a knife. They say if you are in that sort of lethal threat scenario, you can use whatever you need to that's reasonable in self-defense, and reasonable is going to depend on a whole bunch of things like, it may not be reasonable to defend yourself against a water gun with a real gun, but a knife is a lethal threat. If somebody's trying to stab you, that could very well kill you. So, and people have sort of latched on to the Iraq aspect. And on one end, you can say certainly things appear to have been dangerous. If somebody's attacking this guy with a knife and he's got to defend himself, and maybe he could have been killed if he wasn't. But really, we don't know if the jury accepted that. We don't know if the jury was like, oh, yes, it is dangerous like Iraq, or if the jury went, nah, we think that's no good, because we don't actually get to find out what juries think in Canada. We can't even, even if you knew who the jury was, you couldn't pull one of them onto your show and say, hey, can you explain what the jury was thinking here? Do you know, was this, were you persuaded? Were you not persuaded? The other thing to remember is always that Canadian law has the standard of proof beyond a reasonable doubt.
Right.
And that's something a lot of people sort of find difficult to grasp, because once in a self-defense case, once self-defense, there's an air of reality to it, that it's not sort of a ridiculous argument. The Crown has to prove that it was not self-defense to a beyond a reasonable doubt standard. So the jury could still have been thinking, this guy is probably the bad guy, that this was probably bad self-defense, or even that it was very likely to be, an improper killing. But if they can only get to very likely, that's not good enough. The standard is basically either certain or almost certain to us. Like, we sort of, if it's a legal error to give like a number to it, but typically in law school, they'll say like 90 to 95% certain kind of standards. So if they're anything less than that, if they're only like 80% sure that, that this was improper, the shooting, then they have to acquit.
Yeah.
So,
According to the Toronto Star report, the fellow was lunging at him with a knife. He did have a knife. It was uncertain what was in his pocket because it was sort of concealed. And I mean, if he had been shot at before. I went to law school a long time ago, and I really never practiced criminal law other than when I was at the student legal clinic. But if I remember correctly, the law of self-defense is you shouldn't be weighed to a nicety, if I remember that phrase, as in, jury 3 years later, calmly, oh, you weren't precise enough. It wasn't perfect decision making. And you correct me if my memory of law school 30 years ago was wrong, but a jury is not supposed to demand perfection from someone who is in a crisis. They're being attacked by someone with a knife. Is he being 100% careful? So I suppose that goes to your point also, is you don't have to be perfect. If you think your life's in danger, and if that's reasonable, you can shoot back.
This report is brought to you by...
Gun bans make great distractions.
Trudeau may be gone, but Carney has picked up his same rhetoric.
We will quickly, and I mean quickly, reinvigorate the buyback of assault-style firearms.
Hunters, collectors, competitors, and defenders of tradition are still being targeted. While criminals run wild under Liberal policy. But we are fighting back. By delaying and dismantling unjust legislation, by confronting policy at its source, like on the global stage at the United Nations, through our unmatched record of political lobbying and our Save Firearms program, actively saving firearms from government crushers in real time. And we're not done yet. Join us. Canada's National Firearms Association, in defense of freedom.
absolutely correct. And in fact, the line, I believe, is you don't have to weigh your behavior to a nicety in the face of an upraised knife. So exactly this kind of scenario. And one of the things that intends to consider is that, right now, sitting in a couch, with a, just with lots of time to think about it, you can often say, well, what if you would have done something else? Like, what if you could have done, and it doesn't have to be the right answer or the perfect answer. It just has to be a reasonable response. That's the sort of standard that's built into the law, is reasonability. And sometimes reasonable can be a range of things. It might have been reasonable to run away, but it might have been reasonable not to run away. These kinds of issues. So it's very much a don't sort of, Sunday morning quarterback kind of thing.
You mentioned a jury trial, and I don't think we have as many jury trials in Canada as they do in the States. You would probably know the stats better than me. And I can understand a jury might be more sympathetic because they might look on this, he was 17 at the time. They might have more sympathy, perhaps. But one of the things is the jury does not write detailed, perfectly worded reasons. And so in terms of a legal precedent, we don't actually know what the rationale was. Like you say, was the jury impressed with this young man? Were they on the edge? We don't know. And we just have to accept the jury. And I think, by the way, I would trust a jury. I mean, I would imagine there might be some extremely technical kinds of cases, a technical kind of fraud or something that a jury might not be equipped to handle. But a schoolyard brawl, I can't think of anyone from any walk of life who wouldn't have some innate sense of that. So in this case, it worked to the benefit of the accused, but we just can't apply this to other situations, right? Because we don't know their thinking. There's no precedent here.
Yes, absolutely. We don't know what the jury was thinking. They don't give reasons. We can't even ask them reasons. And sometimes their reasoning might be things like, we don't believe anybody.
Yeah.
If they don't believe anybody in this case, they would just have to acquit. The other thing I sort of always caution, I get people who ask me about self-defense in hypotheticals all the time. Like, if somebody pulls a knife on me, what can I do? And they can be very, very exact, like very fact specific. One little detail that changes between one case and the next can dramatically change the assessment. And so it can be very dangerous to make big assumptions from one case that, like, okay, well, it's always going to be okay to shoot somebody if they pull a knife. That, it may usually be okay if they're trying to stab you to shoot them, but that's not always the case. And so it's very difficult. In general, the rule in Canada would be that if you've got any other option, you should be taking the other option other than using lethal force. Lethal force really is always to be the last resort, but that doesn't mean that everybody who uses lethal force will necessarily be convicted, is the other thing. But going through the process is also itself difficult, because I don't know how much, this young man and his family will have spent. I don't know if they got, assistance with it or anything like that. But a court case, especially one involving a murder, can be incredibly expensive.
Yeah.
6 figures would not be a difficult spend on something like that.
It wouldn't
And
surprise me
so,
if he
yeah.
had some legal aid, if his family sounds like they were refugees from Iraq. I mean, who knows? Perhaps he was sort of a wealthy merchant, but it doesn't sound that way. So I guess one thing you've really helped me think through clearly is, if the act of shooting a would-be knife killer was found defensible, or he was acquitted of it, that doesn't mean he's off the hook. As you say, he's still in jail. So he is, it sounds like he's facing other firearms offenses, having the thing. It was just the killing his assailant that was excused. So this, even if this were a judge-written ruling, it might help us understand the law of defending yourself, but it wouldn't necessarily give any lenience to, well, how did you get the gun? Who did you get the gun from? Why were you carrying the gun? And by the way, he got it from a friend. I mean, it sounds like this was a terrible neighborhood. It sounds like he's not too far from the truth when he describes it like Iraq. I tell you one thing, when I was growing up at my high school, there weren't people bringing knives and guns around. It sounds like a pretty rough place. It sounds like those things are still before the courts, perhaps, even if that one part of the story, the shooting, is now closed.
Absolutely. And this is very common. You'll see court cases where, for instance, a drug dealer was attacked by a rival drug dealer, and, they have a gunfight. The loser, of course, dies, but the winner ends up, they get cleared on the murder charges, but they still end up, you'll see like a sentence of 3 years or something like that, because you had the gun, you were not allowed to have the gun. So they end up doing some time over that. But of course, the drug dealer is probably happier doing the 3 years than being the other guy in that gunfight. So it also becomes a little difficult, because if you don't have the firearm in a self-defense case, well, so I don't know that there's really a good answer here. And unfortunately, we're just sort of, as a society, left to choose from a range of bad answers. But that all the people who've said that, he's getting away scot-free are probably wrong. There's probably going to be some sentence for having the firearm itself.